It can be risky for a person to provide information on corruption, in other words, to whistleblow. A whistleblower can often be at risk of reprisals for their actions, especially from the people they inform on. This is why strong whistleblower protection is the key to taking down corruption. In Malaysia, the Whistleblower Protection Act 2010 provides whistleblowers with several protections, such as confidentiality and protection from harassment. Despite this, there are several areas where this law needs urgent reform. Here are some examples. 1. The Whistleblower Protection Act 2010 does not protect every whistleblower. To qualify for whistleblower protection, an individual must disclose their information to specific enforcement agencies, such as the MACC or police. Furthermore, a whistleblower is not allowed to disclose their information to other parties after sharing it with an enforcement agency. Are these limitations necessary? Several countries, such as the UK and Australia, afford whistleblower protection even if information is disclosed to non-enforcement agencies. Why shouldn't our law provide protection to whistleblowers, no matter who they disclose their information to? 2. Whistleblower protection is only given for information not prohibited by any written law. In Malaysia, many government documents are automatically classified as official secrets under the Official Secrets Act 1972 or the OSA. Disclosure of these official secrets is illegal. This means that if you disclose information on wrongdoing by government bodies or public officials, and that information is classified under the OSA, you will not be entitled to protection under the Whistleblower Protection Act. Worse, you could even be arrested or prosecuted for alleged breach of the OSA. This makes it extremely difficult to call out corruption from within the government, when this law should be making it easier. 3. Whistleblower protection can be revoked. A whistleblower's protection can be revoked if the whistleblower participated in the improper conduct disclosed. In their disclosure, they made a statement they knew to be false. Their disclosure is frivolous or vexatious. Their disclosure principally involves questioning the merits of government policy, or their disclosure is made to avoid dismissal or disciplinary action. These reasons need to be relooked at. While there may be times where revoking protection is appropriate, it must be done with the utmost consideration. For example, shouldn't individuals who are part of the wrongdoing be encouraged to become whistleblowers? They would likely have important information that would be near impossible to uncover otherwise. Why should they not qualify for protection? One final issue with the current framework around whistleblower protection is the potential for government influence. Ideally, whistleblower protection should be independently governed for the safety of the whistleblower. However, under the Act, the Minister has power to give directions to the enforcement agencies in charge of carrying out whistleblower protection. These enforcement agencies are duty-bound to give effect to the Minister's directions. Furthermore, the Minister also has the power to make regulations meant to enforce the provisions of the Act. This places a great amount of power in the hands of the government. If a whistleblower seeks protection for exposing an individual and this comes into conflict with government interests, it is possible for the government to take advantage of the law and influence the protection of the whistleblower. While the Whistleblower Protection Act does offer some protection, more must be done to protect the whistleblower. A reform of this law is urgently needed if Malaysia is serious about taking down corruption. We must encourage whistleblowing. To do that, their protection must be the priority. To find out more about how you can be part of the movement to increase protection for whistleblowers, visit c4centre.org.